Hello and welcome back to Business Live Middle East webinar series on business continuity during COVID-19. My name is Poonam Chawla and I am the Associate Publisher of Business Live Middle East. In this series, Business Live Middle East is collaborating with industry experts from GCC to gather insights and advice on specific challenges and best practices and innovation that can help organizations manage during these times. We are in the middle of the fastest transformation the global economy has ever experienced. The coronavirus pandemic has resulted in billions of people not being allowed to work and having to stay at home. Several millions face unemployment and governments are working day and night to provide financial and medical support. It is also an incredibly testing time for the functioning of the organizations. The COVID-19 pandemic has potentially compromised the ability of companies to undertake effective compliance monitoring, supervision, and oversight, creating an opening for economic crime and other unethical behavior. Business Live Middle East webinar will focus on sustaining business continuity and evolution during and post-COVID-19. We also call on companies to resist the temptation to sacrifice their controls, systems, governance, and appropriate culture in adjusting to the new realities of COVID-19. I have with me Mamoon Khan. Mamoon is a partner in the banking department at Al-Tamimi & Company, having specialized in banking, corporate lending, project finance, and aircraft finance transactions. Before joining Al-Tamimi & Company, Mamoon worked for Orr Dignam & Co., a law firm in Pakistan. Following his call to the bar in 2001, and was primarily involved in banking and corporate finance work, including mergers, acquisitions, and privatizations, as well as advising on project finance, derivatives, and capital market transactions. Thank you so much for joining us today, Mamoon.
Thank you very much. We are delighted to join this webinar in order to advise on the legal aspects of contingency planning and business continuity. Thank you very much.
Next, we have Ms. Natalie Jones. Ms. Jones is an experienced senior associate who joined Al-Tamimi & Company's employment practice in 2012. She advises clients throughout UAE, onshore and in the free zones concerning all aspects of UAE employment law compliance, from the onboarding process, day-to-day management of employees, and advising on termination and post-termination issue. Welcome on board, Natalie, once again.
Thank you. Happy to be here again.
Thanks to both of you for joining us today. Before I begin the discussion, I would like to inform that audience is free to pose questions during the webinar, which will be answered towards the end of the session. You can use the Q&A icon displayed on your screen to type your questions on the dashboard. Kindly mention your name, organization, and title, and whether you would like to ask specific speaker to address your question. Lastly, the audience also has the option to use the raise hand feature, an icon that appears below, and I'll come back to you during the webinar. Let's get started. As companies navigate the ongoing COVID-19 crisis, there are a number of key issues corporate leaders should be thinking about, as well as steps they can take to not only react to severe business shocks, but also reshape their business and plan for recovery. Mr. Khan, we always say crisis is something which we never expect, but this really is, which has shaken the entire world. You know, for many years, we have companies use scenarios as a tool to help understand what the future might bring and a framework for how business leaders could plan and prepare. But in the current scenario, this type of planning is particularly challenging since the short term unknowns are in some ways greater than the long term uncertainty. So, Mamoon, can you give us an overview of the Central Bank of UAE's directive on relief packages to banks, customers, and borrowers?
Thank you very much, Poonam. Poonam, as you're aware, in response to the COVID-19 situation, the UAE Central Bank had recently, at the end of March, issued standards for its Targeted Economic Support Scheme, otherwise known as TESS, with the focus largely on private companies, small and medium-sized enterprises, and individuals. In summary, TESS, or the Targeted Economic Support Scheme, targets three principal aspects. Firstly, which is more for the bank itself, funding relief to the banks by availing a zero-rated facility from the Central Bank of the UAE up to the amount of 50 billion, which is spread across all the local UAE banks as well as foreign banks operating and licensed in the UAE. Secondly, there's a relaxation on capital buffers for banks, which then allows them to tap into the capital conservation buffer up to 60%, and in certain instances, up to 100% for local banks. With that, the scheme also imposes a temporary suspension on banks on maximum distributable amount from their earnings, thereby plowing the money back into their business. And most importantly, this is for, of course, customers and individuals and borrowers. The banks have been directed to offer a 6-month deferral loan repayment period to private companies, SMEs, and individuals. And most recently, the central bank this week also directed banks to defer the interest payment as well. There was some ambiguity in the past, but now the interest payments accruing during this deferral period will also be deferred to a period agreed between the customer and the bank. They also have been directed to extend the loan periods and not to charge any additional fees and penalties. And lastly, which is very important for customers operating in this jurisdiction, there is a mandatory requirement for banks to report any downgrades back to the central bank in relation to their customers. So any relief packages being offered to such customers, those customers will not be downgraded, because there is a direction by the central bank not to downgrade such customers and report them back to the central bank. There is a very specific point I'd like to highlight at this point. There is some ambiguity in the guidelines in relation to unfunded facilities, which is in the form of a letter of credit or a bank guarantee. It is important to note that at the moment, the guidelines talk about installment repayments, but businesses also, and mostly trading businesses, have these bank guarantees in the market or letters of credit issued on their behalf by banks, which if they are invoked, there is a possibility the banks may either set off the funds which are in their bank accounts or request monies back immediately. So this is something to discuss with your banks at this stage, that if these banks are utilizing the relief scheme from the central bank, they should also be offering some similar stimulus packages for these unfunded facilities.
Interesting. How are banks using Central Bank of UAE's targeted economic support scheme to actively mitigate the repercussions of the COVID-19 pandemic, as well as provide necessary relief measures to finance businesses and other economic sectors?
We understand, we only have anecdotal evidence supporting the directions of the central bank. We understand that most of, in our discussions with banks, that most of the local banks and some foreign banks are accessing the zero-rated facility. And in a recent statement by the central bank, we understand that 30% of the funds have already been allocated to these banks. So that's the first sort of a measure that we have in terms of utilization of this facility. It is also important to note at this stage that if the banks are accessing the stimulus package by the central bank, they would need to provide the relief to the customers and work within the parameters of the guidelines. Therefore, it is important in terms of any contingency planning also to inquire from the banks whether they're part of the scheme or not. We also understand that from a more housing finance and personal finance perspective, that some banks are providing relief on a case-to-case basis, and we have observed that banks have taken a risk-based approach and providing relief on a monthly basis. So they assess at the end of the month a financial condition of each customer, and then provide the requisite relief. So it's important to check with your relationship managers on this aspect.
Okay, you just mentioned that 30% of the banks has already, been allocated to these banks. So which are the banks who are using these facilities before we come back to another question?
We don't have specific evidence. I mean, in terms of naming, our understanding is most of the larger local UAE banks, which are the most obvious ones, are availing the facilities. We are also aware of certain large foreign banks, which are licensed by the central bank, have also looked into availing the facilities. But specifically, the central bank has not come out with the names of these banks. There is a reporting requirement by these banks to report at the end of each month back to the central bank if they're availing the facility and how they're doing it. So once that reporting is effected, central bank may come out with potentially a list of banks who are providing such relief.
Interesting. Can you also give us an overview of UAE bankruptcy as well as corporate insolvency laws? What are the options available to someone filing for bankruptcy during these times?
I hope that most of the participants will not come to at that stage. But just to give you an overview, as you're aware, the UAE implemented the insolvency law for commercial companies and for traders back in 2016, and then more recently a new bankruptcy law for individuals. We'll discuss the corporate insolvency law here today, but that's the mandate. Was introduced back in 2016, and it introduced a rescue mechanism for distressed entities in the form of what we call a preventive composition for an early stage distress, as well as a debt restructuring within a court-administered bankruptcy, and along with certain relief to distressed debtors during the process of adjudication of the bankruptcy. The bankruptcy regime has also allowed distressed companies to seek protection from certain trigger-happy creditors who are used to more traditional process of debt recovery in local courts. So there are certain protections that's been afforded to, which I can elaborate in this presentation.
Okay. A special thing for our participants, we have a Q&A where you can type in your questions, which we will be asking our panelists post this discussion. Mamoon, coming back to our discussion, for those looking for guidance on the due processes, can you give us an idea of how each of these works? Like, we are talking about preventive composition,
yes,
restructuring within bankruptcy, and liquidation.
Yes. So as a starting point, the bankruptcy law provides for a protective mechanism called preventive composition, which is essentially in the early stage of your distress when the borrower is not defaulted yet. So a debtor can apply to the court for a preventive composition prior to such customer or debtor defaulting on the debt. And this is under the law precisely 30 days prior to the debtor failing to pay its debt, which is due on account of either a financial instability of such debtor or its liabilities are exceeding its assets, basically a balance sheet form of insolvency. So financial instability is essentially interpreted as the depletion of revenues of a debtor. So it's a form of a cash flow test, that the cash flows are completely depleted, and that's one of the conditions. If they are met, prior to any default under a loan or another indebtedness that a debtor can file for preventive composition. After the 30-day period that the debtor is now defaulted, it is generally mandatory for the debtor to file for bankruptcy under the law. However, generally the debtors either fail to immediately apply for bankruptcy or otherwise wait before the financial condition further deteriorates. It is important to note at this stage is that the bankruptcy law does not provide for any penalty for not filing for bankruptcy, even at the mandatory stage. And our understanding from the more jurisprudential research that we've done is that there is always a legitimate expectation by a debtor that the financial condition will improve, the cash flows will revive. Therefore, that's the reason that the debtor delays in filing for preventive composition or even restructuring within bankruptcy. In terms of restructuring within bankruptcy, this is the second option, which can be filed either by a creditor or the debtor and itself. And this is where you've gone beyond the 30-day period. The debtor ceases to repayment of its debts on their respective due dates for more than 30 consecutive business days. Again, the conditions are due to financial instability, which is again a cash flow test, or the debtor's assets being insufficient to cover its liabilities. Again, balance sheet insolvency. So that is another sort of way which is beyond the default that you can file for a restructuring protective option within bankruptcy. Then lastly, you have liquidation. This is, I think everybody is aware of this. This is more of a straightforward process where there is not much hope to salvage the business, and the debtor can essentially file for an voluntary liquidation of the company and the sale or the distribution of assets to the creditors under a more court administered plan. It is important to note the process here. The process is very complex, but I will just give you an overview of summary of what, how whether you apply for a preventive composition or restructuring bankruptcy, how the process is implemented. Um, in order to file for either a preventive composition or bankruptcy, the debtor is required to essentially submit a shareholders resolution. And along with the shareholders resolution, it is required to submit certain documents which are prescribed under the law. The documents are in the form of a statement of claim, a statement of account, a list of creditors, detailed business plan that how will this company revive this business. All these documents are submitted to the court, and once documents submitted, the court essentially appoints a court-appointed expert, which essentially provides guidance to the court whether to even accept the bankruptcy or not. So there is always a risk that the bankruptcy, if it is not accepted, the court may view to put the company into liquidation. So there is a key risk here which needs to be highlighted at this stage. If the composition and restructuring is accepted, then the trustee in bankruptcy that's appointed will work along with the debtor to form a resolution plan, which has to be voted on by 2/3 of the creditors, all the creditors, including secured creditors and unsecured creditors. So once this plan is put to vote, then there is a period of a scheme of approval by the court. And once it's approved by the court, it's then sort of put into implementation. And then the court oversees the restructuring process along the way. One relief to the debtors here is that during the process of the acceptance of the application of bankruptcy and the resolution plan, all existing cases, criminal or civil, are suspended for that period. So that's a relief that's provided by the bankruptcy law, that any check bouncing cases, which are quite common in the UAE, any civil cases and precautionary attachments will be suspended for that period. And of course, once the restructuring plan is implemented, there is a mandatory obligation to withdraw those cases.
See, in these unprecedented times, this is just, do you see a lot of companies filing for bankruptcy?
Because the registers of the court are not open to public, in our sort of review of the informally the review that we've done, there are about, since the law was passed, there are about 25 to 30 cases in court at the moment. And I will make a comparative analysis with India. India also brought a similar law, which is, I think, colloquially known as the insolvency bankruptcy court. They have about 1,500 cases in Indian courts at the moment. So the comparison is quite, the gap is quite big. I think the population of the UAE is smaller, but we still feel 20-25 cases are much less than compared to other parts of the GCC or the
But
country.
if you compare it percentage wise, the global percentage of these, insolvency submissions, how do you compare that?
Very, very small. It's a very, very small, minuscule percentage in the UAE. I think it's also the lack of understanding by the debtors of the insolvency process. I think we saw a flight of sort of shareholders leaving the country and trying to manage the business remotely, or what we otherwise call just the business dying its own natural death. They're not just plowing any other monies back into business. They're just not doing anything. But the law does provide for a rescue regime. I think the idea for the government was to for debtors to utilize it and try to get some protective measures. Yeah,
I
but I
think
think it's
you
still.
rightly said, yeah, most of the debtors are not aware of the government initiatives in this regard. And that's the reason, most of them either leave the country or try to, control it remotely and revive it.
Yeah. There's another reason as well, which is that and this is for the more aware debtors, that there is always a risk that you might lose the business completely, because the granting the protective measure is at the discretion of the court. So if an expert is appointed by the court, an expert analyzes all the financial health of the company and the projected business plan, and comes to a conclusion that there is no hope to salvage this business, so restructuring is not possible, it will put the company into liquidation. So that's also another risk the debtors may face, and that's one of the reasons they may want to just fight it out as opposed to go for bankruptcy.
Okay. Mahmood, contingency plan, as we have just discussing, is a vital part for any organization or business. It becomes all the more important during times of crisis. How can one create a pragmatic contingency plan that covers all possible scenarios? Rather, this is one question which has been, a lot of our participants have been emailing us regarding this. So if you can throw some light on this.
Yeah, I mean, I've got some practical suggestions based on the legal aspects that we have, or the legal regime that we have in the UAE, and over our experience with sort of restructuring debt for debtors and creditors here. So I'll give you more practical suggestions which businesses can look at. I mean, as you're aware, these are very difficult times. Businesses have to look at, I guess, replanning their existing business. I think preservation of cash is extremely important. Avoiding capital expenditure unless it is essential. That's one way. Focus on collections and stretching out their payables. That's one way of doing it. Basically, developing a liquidity strategy for the immediate future. And I think doing some risk analysis in terms of the existing business, and the critical one is how to deal with creditors, which is, I think, that I'll probably allude to now. So once you assess the financial health, the expectation of future cash flow, and a mechanism to preserve cash, it is very important during that stage, through your corporate governance process, through your internal processes and controls, to begin interacting with your creditors, including banks and financial institutions, which perhaps in a certain instance are your significant or substantial creditors. And I think the first point is, particularly for UAE borrowers, is to assess whether such creditors are still part of the test guidelines. So the stimulus package that's been provided by the central bank to these banks, whether they're part of the scheme, and if they're part of the scheme, what sort of relief that they can obtain from such banks. So that gives them a certain vacuum period if their local banks are part of the scheme, and they can sort of stretch out their loan repayments, interest repayments, and other unfunded facilities, get some relief at that end. Now, when dealing with banks, make sure, I think this is a very important point, and I'm sure the banks will not be happy when I'm telling you this, that deal with the relationship managers or any restructuring officer in the bank. Avoid dealing with the remedial officers in banks, because remedial officers are largely they have a bottom line to fulfill, and they are very trigger happy in initiating litigation against debtors. So relationship managers are more sympathetic. So these are all the restructuring officers which are looking to restructure the debt as opposed to take any adverse actions. That's one point. If you have multiple creditors or banks, perhaps consider dealing with them collectively as opposed to individually, in order for the stronger creditor in that group to control with the smaller lenders. So we've always seen that to be very helpful. If you have a bank, a stronger bank which is willing to support you, it will bring in line some of the smaller creditors. So it's quite important to deal with them collectively. And if you're dealing with them collectively, perhaps when you're in a dire straits or in your dire distress, but you have still an expectation to revive the business, perhaps discussing an informal, what we call a standstill agreement, which essentially imposes a moral obligation on these creditors not to take action whilst the restructuring negotiations are taking place. So that's one way of dealing with the creditors and multiple creditors. You could also look at appointing a creditor committee with a lead bank to help you steer through the restructuring process. Now, it is very important, and this goes back to my analysis on the on the bankruptcy law, and which I will further sort of discuss in terms of the penalties, is to deal with all the creditors equally. Be very transparent with them, not to give preferential treatment to one creditor over the other, because eventually, if you do go into bankruptcy, that is a penalty that can be imposed on you if you were found to be dealing preferentially with one creditor over the other. However, you could be in a situation where you may have to prefer one creditor over the other given your current financial condition. I can give you an example here. You could perhaps prefer a creditor which is extremely essential to your business. For example, your raw material supplier, or any counterparty which is providing services which are extremely critical for the preservation of your business. So perhaps that is one area where you can consider preferring. Then you may have in your group of creditors certain secured creditors who hold a preferential debt. For example, they hold a mortgage or a pledge over your assets. So those could perhaps rank a little lower in your priority, because you know that they have a secured asset and they'll be more willing to be forthcoming, given that they already have certain rights over your assets. Lastly, for any potential restructuring, it would definitely benefit appointing a skilled financial advisor to steer through these troubled waters. A financial advisor can essentially help you assess the current nature of your business, your expectation of cash flow, and they also are very experienced in dealing with creditors. So I think that's quite an important point, that financial advisors, sometimes there are quite a few in the market which would help you. Financial advisors can definitely come in handy when you're dealing with multiple creditors.
Interesting. What potential risks, liabilities, and obligation, should the management or top tier, keep in mind when they are creating a contingency plans? How best do you think, one can mitigate these risks and liabilities?
That's a very broad area. I think in order to respond to this particular question, I think first we need to understand who the management is in a corporate entity or in a small and medium-sized enterprise. Effectively, from a UA perspective, who's the manager? Management is not very clearly defined in the bankruptcy law. They've kept it either deliberately or inadvertently vague. So they've not discussed the true manager under UAE law, which is essentially a manager who's named on the trading license of the business. The bankruptcy law defines a management as any person who can exert influence over the decision making of the company, and they've left it at that. What we otherwise in common law jurisdictions may also called shadow directors. So you may have manager appointed or directors appointed under the constitutional documents, but then you have other people in the management who are not formally part of your corporate documents, but are in the form of a CEO or a CFO or a chief operating officer, or other finance managers who may also be liable because they are exerting certain influence in the decision making of the company. So it's very important to understand who the manager is. Now, in terms of the awareness of liabilities, I think any manager who is in control of the decision making, the first trigger is, as I've discussed, when you reach a stage that you should be filing for something called a preventive composition. I've discussed earlier, the preventive composition is when you're in the early stages of a financial distress. So that's probably the trigger that you're first, you know for a fact that you will default in the next 30 days in your debt. So any period prior to the 30-day period, usually the law prescribes a period of 2 years, is where the management should be aware of not taking any unnecessary risks, which would render them liable. The management or the manager at that stage should consider the following actions which can potentially hold them liable. Sale of any assets of the company under value. There is no prescribed valuation, but anything with under 20 to 30% can potentially trigger an undervalue sale. Any disposal of assets which has no benefit to the company. So, for example, if the assets are sold and the shareholders have kept the money to themselves, they've not put the money back into the business, this would be considered such a disposal and could be held liable. Hiding of assets, concealing of information, removing of assets from the jurisdiction uh, 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 is again another action which we need to be careful while taking in that preferential period. Preferring creditors, I've discussed that before. This is also if you're preferring one creditor over the other, or you're managing your creditors in a way that it harms the general body of creditors, is also something that will be looked at adversely by the bankruptcy court when looking at the management's liabilities. So these are essentially what the management need to be aware of. In terms of potential liabilities, as I've discussed, there is no liability or penalty for not filing for bankruptcy, as I've mentioned earlier, because there is a legitimate expectation that there will be a revival of business. However, the bankruptcy law does provide for various penalties, which range from prison terms up to a maximum of 1 million dirhams in fines, if the management is found to have taken any actions which are adverse to the interest of the company. And there's one particular one just like to highlight, which is something that we've not seen in other jurisdictions, which has been brought in here. We do not have the underlying reasoning for it, but it is quite a strict liability. It is where the bankruptcy manager or a director, without any exceptions, it's very clear, if it is determined that such manager or director is responsible for the company's losses, where the company's assets are not sufficient to pay 20% of the company's debt. So that's quite a lower threshold, and most of the debtors are who are aware of this provision in bankruptcy law are quite keen to understand this. But unfortunately, there's been no, I guess, jurisprudence on this or interpretation of this. So it's more of a strict liability that if the company is not able to pay through its assets 20% of its debt, and there is a causal link between the manager or director to the company's losses, then those debts will be paid by the manager or the director.
How do you
So
establish that causal link between the director and the company? Because as per
this
my
is some
knowledge, there are a lot of companies where you have the CEO or general manager as a signing authority also, because that's a prerequisite to do any government transactions. So
Exactly. I mean, that's the unfortunately that's it is what it is in terms of the law, but the link would be determined by the court itself. So if as the actions that I have mentioned earlier, the sale of undervalue assets, preferring creditors. All those factors would constitute, and if a particular manager or a director has been named in certain corporate documents to have taken or influenced certain decisions, that's where the court may establish the causal link between the company's losses and the actions of the management. In terms of mitigation, now this is where this is quite a broad brush of actions that the management can take, which would help in mitigating such risks. The law uses the term called necessary precautions without really defining it. So when taking any actions in that particular period, the management should be taking necessary precautions when taking any decisions, which in our view essentially translates into being very transparent with all the dealings, which comes down to the corporate governance within the company. Essentially minuting all your decisions, documenting all decisions for all future evidentiary purposes. So if a particular manager is not comfortable with a decision being taken by a shareholder in relation to the company, perhaps making official protests, making reservations, but either in the shareholders meetings or the board meetings, informing the shareholders and partners of key decisions at all times. So you're not in a position where the manager has taken a decision and the shareholder or a partner puts up a defense that they were not aware of it. So keeping all the paper trail, keeping the chain of correspondence with the shareholders, making them aware of the financial condition of the company and the actions being taken, seeking their consent where required, pushing decisions upwards to the shareholders. That's quite important. If the senior management is not comfortable, perhaps pushing it up to the shareholders for them to take the decision. It is, and as lastly, the most important point is preparing and maintaining sufficient evidence on record that all key decisions that were taken by the management were in an effort to minimize the losses of the company. So this is very fundamental to when you come to the bankruptcy stage and there is a potential risk of director's duties or manager's duties, you have succinctly or comprehensively provided in your resolutions that all the key decisions were taken in an effort to minimize the losses of the company.
Interesting, Mahmood. Is there any, like you have mentioned that we should keep a record of all the communications, we should raise it to the shareholders if we feel that there's a need be. But is there, should one also ensure the legal language and the tone of corporate authorizations in circumstances of financial distress?
That's very important. That's also important for non-financial interest aspects as well, because in our experience, we see very skeletal form of corporate authorizations. So we sometimes even see 2 to 3 liner corporate resolutions. I think the most important thing is to be more descriptive in your resolutions. That's what that will reflect the corporate governance of your company, a good corporate governance of your company. So I think the first point is to duly minute all resolutions, directors, shareholders, and managers, and particularly in financial distress, even the communication between the managers and the shareholders need to be reflected in a proper correspondence and duly certified. Again, it's important to certify the corporate authorizations with the signatures of the key directors and perhaps a majority or even sometimes all of the directors and partners, which gives a more of a credence and certification to that resolution. And again, whatever decisions that have been taken, which may reflect in the best interest of the company at that stage, needs to be shown in the resolution that they were taken given the current circumstances. These decisions are being taken in an effort to minimize the losses. So perhaps reflect back in the resolution itself. And I think lastly, all corporate authorizations need to be recorded and produced. So if they need to be made available at every stage when it's required.
Interesting. We have a lot of questions, Mamoon, and we will come back to you at a later stage. We will have Natalie on board with us. Natalie, we have seen unprecedented measures being taken by the UAE to prevent the spread of the disease, including mandatory work from home instructions and business shutdowns. However, there has been uncertainty, as to what steps can an employer take to mitigate the impact of the virus while protecting the rights of the workforce during this unprecedented time? To address this, as you have mentioned in our last conversation, the Ministry of Human Resources and Emiratisation has published a new resolution, and I think this resolution is a good testimony which gives a welcome guidance designed to help employers to navigate difficult employment issues which are rising in connection with these crises. So if you can give us further insight into the amended labor laws which are affected by the coronavirus situation. So how does the Ministry of MOHRE new resolution apply to in specific?
Yeah, so you're right. The authorities have taken steps to try and help in this time. Is unprecedented, and I think the authorities are doing what they can to try and assist at this point, particularly for in the context of the employment relationship. And the new resolution, I think we're talking specifically about Resolution 279 of 2020. That resolution, strictly speaking, applies to all entities under the remit of the ministry. So they will be basically the entities that obtain work permits or labour cards from the ministry when they're onboarding employees. Strictly speaking, the remit of the resolution would not extend into the free zones. Having said that, some of the free zones are now coming out and basically implementing the resolution. And in addition to that, we expect that the courts and the authorities more broadly will expect most entities within the UAE to act within the spirit of the resolution and therefore to comply with the terms of that resolution.
Interesting. We have permitted measures to ease financial burden of employment costs on employees. So what are these permitted measures under this resolution?
Yeah, so the resolution provides a number of actions which can be taken by employers. I think it's important to note at the outset that the labour law still governs the employment relationship in the UAE outside of DIFC and ADGM. So where there is a conflict, the labour law does still apply. But what's useful in the resolution is that it reflects a number of provisions that haven't been set out in law to date, so that the labour law, for example, doesn't provide for. In very short terms, the resolution provides that employers can place employees on remote working, so they can work from home. And in actual fact, they're mostly required to at this point, given the lockdown, particularly in Dubai. It also provides for employees going on paid leave. That's not anything new, and the labour law does allow employers to place employees on paid leave at its discretion in any event. The new provisions that have been provided are unpaid leave, which hasn't been set out in law to date, reductions in salary both for a temporary period and for a longer period, although the relevant periods are not set out in the resolution. And in the resolution also provides in some terms for a provision of redundancy. It doesn't say specifically about redundancy, but it does say it does contain guidance for employers in circumstances where the employer has a surplus of employees as a result of the current situation, and it provides steps that must be taken by those employers in that situation. I think it's important to note that when we're talking about unpaid leave, reductions in salary, whether temporarily or longer term, the employer can't act unilaterally. So it is not the case that the resolution allows employers to impose unpaid leave or reductions in salary. Instead, in all cases, employee consent must be obtained. And quite helpfully, the ministry has provided a document that must be entered into between the parties that will act as an addendum to the employment contract filed with the ministry. It's quite a simple document and basically allows the parties to tick what measure they're putting in place, whether it be unpaid leave or reduction in salary, and set out the time frame within which the measure will be in place. And it also allows for signatures by both parties so that there isn't a dispute in the future as to whether the parties agreed with the terms or not. Strictly speaking, the way the resolution is drafted, the measures set out in the resolution should be followed in the order in which they are set out. So, for example, remote working, paid leave, unpaid leave, reductions, and then redundancy. There are, however, no penalties set out in the resolution, and therefore we obviously don't know at this point in time what the repercussions would be if the steps were not taken. But I expect from experience with the courts that it would be a question of how sympathetic the courts would be if there was a dispute. So, for example, if an employer can show that it followed the resolution exactly and took all steps, for example, to maintain employment and to consult with employees, etc., followed all of the measures in line and in order, I think the courts would likely be more sympathetic than if an employee could demonstrate that an employer had failed to follow those steps in order. So it's a question of how the courts are going to deal with a case in the event of a dispute, rather than there being any specific measures at this point to make sure the steps are followed in line.
I think as Mamoon has mentioned, like in this case also, I feel that employers should document all conversations with employees and even vice versa, to document any change in status or any, renegotiation of the contract.
Absolutely.
Yeah. So how long do you think that the employers and employee be subject to the resolution? Is there any time frame which is set for it? Because, this is like an ongoing process. So we don't really see when this is going to end. So is there any specific, timeline which is set for this resolution to be subject?
No, so the resolution doesn't say anything about timing. It has an implementation date of 26th of March, but it doesn't have an end date. And what's interesting is often when resolutions are implemented by the ministry or by other authorities, they usually just say there's an implementation date and they say nothing about withdrawal. This resolution provides, in the context of making employees effectively redundant, the measures that are in place in relation to that will be in place, and this is set out in the resolution, until the earlier of the employee finding a new role or the employee being able to leave when the resolution is withdrawn, which I think is indicative of the fact that at some point the resolution will be withdrawn, but the authorities obviously just don't know the timing of that yet. So I think this is absolutely a resolution that will be in place for probably months rather than weeks, and certainly until we are seeing a real turnaround in terms of what's happening. But for the time being, it's in place, and there isn't any deadline in terms of when it will be lifted.
Okay. What are the employers' rights in respect to COVID-19 and reducing entitlements?
Yeah, so as I mentioned, the labour law is still in place at this point, and the labour law doesn't say anything at all about employers being able to reduce entitlements for employees. So we need to look at the resolution in that regard. And employers can, pursuant to the resolution, reduce salaries, as I mentioned, temporarily or longer term, and can put employees on unpaid leave. In all cases, though, we need employee consent. Clearly, you can't, as an employer, force employees to consent to unpaid leave or reductions in salary. And I think that's where it's important. You mentioned about documenting conversations. I think it's important, even before we're documenting anything, just to make sure conversations are happening. So clear, transparent communication with employees. Most employees obviously are aware of what's going on. In the UAE, they can see, for example, that Dubai is on lockdown, that there are restrictions in terms of employees that can go to the workforce, into the work premises, in Abu Dhabi. For example, only 30% of the workforce can attend the office. So this is not something that employees are not aware of. They are aware. And they will no doubt be aware that there will be an impact on a lot of companies in terms of cash flow, because clearly a lot of companies, for example, let's take Dubai, in the malls are closed, therefore retail establishments are not making money. They don't have necessarily money to pay salaries. So I think employees know what's going on. What they need at that point is open communication from the company as to what exactly is happening, in particular in relation to their employment, and what measures are being put in place by the company to try and limit any impact on employees and on the business as a whole, and then try to get employee buy-in. It's very important that basically everyone is in the same boat together, that any measures are taken across the business rather than, for example, in relation to specific employees, because clearly it will be more difficult to get buy-in where individual employees are being targeted rather than at the employment population or employee population as a whole. So yes, it's important to document, it's important for communication, and it's important to do what you can as an employer to save the business and look after your employees at this point.
Is there any specific letter in terms of, terms and details of present salary reduction consent? Is there any specific format which the resolution, talks about, or that's just like we have to document it?
Yeah, so the resolution doesn't necessarily go into that level of detail, but as I mentioned, the ministry does have a document. So for entities that are under the remit of the Ministry of Human Resources and Emiratisation, there's a document that can be used. What I've seen is that some employers who do fall under the remit of the ministry are implementing their own document in addition to that filed with the ministry. And the reason for that is that the ministry document is quite simple. I think that they've done that to avoid overcomplicating matters for employers and employees. Some employers naturally want to put a more detailed document in place, which is fine as long as the ministry document is completed. For employers that don't fall within the scope of the ministry, they still can use the ministry document, and there is a drop-down menu that allows free zone companies to put their details in, or alternatively they can issue their own documents as well. I think ultimately, as long as the arrangements are being documented, and for those entities that fall under the remit of the ministry, that they have the ministry document completed, then we are good, and we have a document to rely on in the event of a dispute, which is what we need to protect the company.
Interesting. What are the employees' obligation, where offices and work premises are partially or fully closed?
Yeah, so there's nothing specifically that relates to that, other than the terms of the labour law continue to apply, and the terms of the employee's employment contract continue to apply, other than where there is written evidence that the terms have been new terms have been introduced and accepted by both parties. So if there is no agreement to the contrary, the employer would still have to pay the employee their salary and any other benefits. Entitlements under the labour law will continue to accrue. So for example, end of service gratuity, annual leave and other leave entitlements. So it is important that employers take a proactive approach in terms of what they are doing, particularly for employing entities that are closed. So they're not, as I mentioned, they're not getting any cash in, and so might not be able to pay salaries, etc. If they just stop paying salaries without documenting that and without getting employee buy-in, they're going to struggle in the event that employees file a claim. So as it stands right now, the labour law is in place, the contract is in place, obligations continue unless there is an agreement to the contrary.
Interesting. I have a lot of questions for you, Natalie, and I'll come back to you in a while. Mamoon, we have a question for you, which is by Ravi Chitnis, who's the Managing Director for Beta Consultants. His question is, pushing the decisions or consent to shareholders, how does it work when there is a separation between ownership and management?
Thanks, Ravi, for the question. In the UAE, it's a little different from some of the other jurisdictions. There is a clear separation in other jurisdictions, particularly common law jurisdictions, between the shareholders who are purely investors and not part of the business decision making, and decision making is best largely with directors. But most of the small and medium-sized enterprises in the UAE and in the GCC to a certain extent, as well as the mid corporates, the investors, the shareholders are not just merely investors, but do participate in the business, and that's the court's approach as well. That they are required to take certain decisions, even though if the constitutional documents have provided a more common law style split between the shareholders and the directors, but the courts would still view and hold liable the shareholders if there's a clear if they were duly notified or duly informed of the decision making, or they influence the decision making.
Interesting. We have another question by Mayank Singh, who's the Director of Business Operations for UMS Group. Mayank's question is, what legal recourse do companies have in dealing with defaulting creditors without resorting to expensive litigation in these challenging times?
Thanks, Mike. I think, as I understand, a defaulting creditor would be your creditor. So effectively, they've not provided. If it's a creditor, it is providing you some financial accommodation, and it fails to do that. Unfortunately, there is a. If you look at the evolution of credit documentation, there is now a concept of defaulting creditors or defaulting lenders in loan documents. But in enforcement, we've not really seen any successful enforcement. This is the most common form of counter claim made by debtors against creditors, stating that because of certain actions, the creditors did not provided us the financial accommodation, and try to nullify their claim. To date, we've not really seen any successful actions against banks. In order to determine, and this is the more of the legalese here, is in order to determine or have a recourse against a creditor, the courts would need you to provide a quantum of the loss suffered by the creditor not continuing with its obligations. And if the debtor not availing the facility on time, and it's able to provide that even with mitigating the losses and circumstances, they could clearly create a link between the creditor's default and the debtor's loss, then yeah, there is room for to seek some recourse. But other than going to court, there is nothing else that can be done. There is no other recourse. The people for banks, I know borrowers have or customers have filed complaints to the central bank, which is then filtered through, and then a recourse has been provided by the banks on the basis of a formal complaint. But short of filing legal proceedings, we've not seen any other avenue to seek recourse.
Interesting. We have a lot of questions for you. Probably, what we are going to do is we will email you those questions and revert back to our participants for those. Coming back to Natalie, we have Zakir Hussain, who's asking, is it mandatory to submit the internal document signed off between employer and employer for reduction of salary for 3 months to MOHRE?
No, so to date we understand that the ministry is not requiring documents to be filed. What we do know is that at least 2 documents should be signed, so or 2 copies of the document should be signed. So using the ministry template, both copies are signed. I also would say in practice, sign 3 copies. And the reason for that would be 1 copy for the employee, 1 copy for the employer, and then you have a spare copy for the ministry should they ask for it, which they might do, for example, to ensure that any WPS wage protection system obligations are complied with. But at this point in time, no, there is no obligation to file the documents with the ministry.
We have another question by Shankar Krishnan. He says that in case employee refuses to accept any of the conditions laid by MOHRE, can the employer terminate his services as per the clauses in labor contract? Also, post-termination, does the employee have rights to approach the court claiming arbitrary termination and demand compensation?
Yeah, so at the moment, and that's it would be a very lengthy answer, so I'll give a short version. Since the labour law continues to apply, and the labour law provides that employees who are dismissed on an unlimited term contract, there needs to be a valid reason for dismissal. A valid reason is generally considered to be poor performance or misconduct by the employee. So in this situation, and just to round that off, if there is no valid reason, the employee can claim and probably will be awarded compensation by the courts. Failure to agree to unpaid leave or reduction in salary is not likely to be considered to be a valid reason for termination. So in that situation where an employee refuses to cooperate and is then dismissed, there is every likelihood that the employee will go on and file a claim with the courts that the company will be unable to defend. Now, for that reason, this is where it's important that the steps set out in the resolution are followed properly, because if they are, and everybody else, for example, if there are 100 employees and only one refuses to cooperate, that the company might have a better argument before the courts than it would have otherwise. So that's why it's important to get employee buy-in. But ultimately, if employees refuse to sign documents regarding unpaid leave or reductions in salary, it will not be lawful to then go on to dismiss them. And there is a risk for the company in doing that.
Interesting. As you know, there is going to be an end to this crisis. The vast majority of organizations have responded appropriately and fairly to the challenges faced and have treated their customers, suppliers, and employees with respect. However, organizations must continue to have an eye towards what's on the other side and ensure that they continue to exhibit high levels of integrity today and beyond. So just one last thing, I would like to have, key takeaways from Mamoon for today's discussion, and then I'll come back to Natalie and we will close the discussion.
Yes, I think for contingency planning and for business continuity, I think the key takeaway to my mind is preservation of the business and the and preservation of the current cash flow. I think that's the key, most important thing. The government authorities and central bank have come out with certain relief packages, which would allow debtors to do financial planning, at least to give them a certain breathing space in order to, I guess, replan the business, managing their sort of corporate strategies, and getting ready for the next sort of immediate future, that is the next couple of months, if as and when the business lockdowns are relieved and they are able to conduct business, so they're ready for it.
Natalie, one message that would be relevant to both employers and employee in these times.
Yeah, I think that the main takeaway for both, from my point of view, would be open communication all the way through. Everyone is being impacted by what's going on, employers and employees, and everyone's trying to find a way through this. But definitely the way everyone's, I think, going to come through it as kind of better off as possible would be open communication throughout, everyone supporting one another, employees and employers supporting one another to get to the other side of this, and hopefully there will still be jobs there and there'll still be cash flow improvement, and everyone will be able to get back to some sort of normality.
I agree with you. We have to get ready for a return to growth. We have to get ready to come back with much more positivity and all. Thanks a lot, Natalie, and thank you very much, Mamoon, for joining us today. I think the session is really very interactive and very interesting, and I hope our participants would have also found it of great value to them all. Thank you very much for joining us today. Thanks a lot.
Thank you. Thank you.